Right.
It's a great opening.
Look at that. Welcome. It looks like St. Patrick's Day. We can rewind things. Good morning, everybody. It's Friday, May 15th, the Ides of May. And we are here in the Senate Economic Development, Housing and General Affairs. And we have had to shift our schedule a little bit. We're kicking up landlord tenant, which we're hoping to get out today. We have a rather slimmed down version of this bill, and we are looking to so I just want to do an update on 775, our housing bill. It's hoping to be voted out of finance. I mean, they voted out of natural resources today, then it will go to finance, and it will, I don't think it's going to have to go to appropriations.
Sorry, I was writing something on my notes about the bill. Is it being changed in natural resources?
I think they're contemplating a change, and
Then
so
can they have me in this speech?
I suggest that. So I would hope that they would. And would you be kind of email Jude and remind her that if they think at which I'm hoping they will,
Yep.
to get ask on 77 if they're taking up. So the challenge for each of our committees is that there's a Republican caucus. So we're losing in each of our morning committees several members of our committee. So, but anyway, that's the hope. Hope we'll have 775 on the floor Tuesday. I hope. Are you meeting, Thomas, on his finance meeting on Monday?
Sure. Not that I know of.
So the other piece of business is I'm hoping we can meet Monday to 11 to 1 to try if we can, or another time that works for people. We just put 11 to 1 because Randy was in the room and he was available. So just because I would love to get Data Broker out, and then we have a bunch of House bills which I think are not going to take us a bunch of time. I think cannabis is going to be quick. I think I don't know about the nicotine addiction, and I think housing is still coming.
Let's get to landlord tenant.
So
I think this is the last bill we need to move.
This is the last one we have to move immediately.
Everything else is optional.
No, H211 is also one of the ones we need to move. So let's start.
On that, Madam Chair, I'm at a place where H211 is incredibly complex, and I just feel like we not only is runway gone, I think the airport is shut down. I'm running. It's an incredibly complex bill that I just don't think we got.
It's not that complex.
Okay, but I'm at a place where I just don't know if I'm ready to move that bill because of its complexity and how I just don't think we gave it enough due diligence prior to now. So that's right. So
I don't think we can lay
I
this complicated bill on a Monday.
Yeah.
Can I just respond?
sure, just responding. Yeah.
Thank you. I appreciate it. I am trying very hard to make it simpler for us. And I think a lot of the I asked you both for your notions of what a clean bill was, and I'm happy to meet with Rick and have the three of us discuss what a clean bill.
Too busy for that now.
Well, there you are. Then you won't be part of that. But I'm happy to have that meeting. I need to understand what that means to you. For me, we might move a meaningful data broker update, pared down, which I proposed last night to several lobbyists, as you know. So I'm open to trying to make it simpler and more straightforward. But I do think this protects Vermonters from data breaches, protects Vermonters from having their
We don't
data
have the
stolen.
language to be able to say that.
We have a whole bill in front of us.
So I
and
think we need to get landlord tenant out.
yeah, I agree.
So
Let's
let's
focus
move
on that
to
today.
If we don't have time before Mark comes in, I would say let's keep doing the landlord tenant bill so we can finish it today.
I agree. I'm
Okay.
right there.
Right.
So, Cameron, would you be kind enough to launch us? We had made some progress. So
Okay, for the record.
remind us where we left off.
Cameron Wood, Office of Legislative Counsel. So very quickly, I will remind you where we were yesterday. So you have the Senate Judiciary proposal of amendment to the House version of the bill, page 772. The amendment that I began to walk through yesterday from this committee is an amendment to the judiciary report. And so if this version that I've been looking at was unedited, and it has since been edited, but so as not to confuse, I'm just going to keep walking through this version.
Right.
So the first instance we talked about, we've struck all of the language. The proposal here is to strike all of the language from the Senate Judiciary Committee related to residential rental agreement matters. We talked about the maximum increase in rent, security deposits, all those sections that you all agreed to remove have been removed. So then we got to this next section regarding the termination for breach of the rental agreement. Still have the medical assistance for drug overdose language here in 3. Have the bifurcation and protection from termination due to domestic abuse, sexual assault, or stalking here in 4A. And where we were yesterday is we got to the section related to the right to bifurcate the rental agreement. We were discussing the language on page 4.
I did have, I believe my proposal was in the termination of rental agreement section.
Regarding,
People with disability.
yes, ma'am. And I mentioned yesterday that that was not in this draft.
Mm-hmm.
So I'd like to just chat about it because my understanding
Well,
is
can
that
we look at the language?
I can pull up the most recent version that I sent you. Is that okay?
Yes. And you had a comment on that version?
Yes.
A further comment.
So it could look something like this. Where depending on what you wanted it to apply to,
Right.
it could say a landlord shall not terminate a tenancy, and it could be under this
And-
subsection, or it could be under subsection 1. So it would
Okay.
be
And then did you have a comment on the piece about saying documented disability?
One of the concerns that I would share with you if you were going to move forward with something like this is at what point in time is the landlord aware or knows that the individual has a disability? So,
particularly one that isn't this.
correct. So generally speaking, an individual who is disabled has no obligation to disclose that.
Mm-hmm.
And, landlords are prohibited from asking about it.
Mm-hmm.
And so if you're wanting to put in a protection that says that you can't terminate a tenancy due to the actions of the individual, if it's related to someone's disability, at some point the landlord may not be aware of that. So if
Right.
they go to terminate the tenancy because of something that the tenant has done,
Mm-hmm.
and then the landlord is made aware that there is a disability, halfway through an ejectment process, what is that? And how would this interact there? So what you could put something in to say that, the tenant has to have requested a reasonable modification or a reasonable accommodation at some point. A concern that I would have with that, I'm not saying you can't do that. It would make sure how you tie the reasonable accommodation to the disability leading to the action that you're protecting from termination
I
from.
guess what I'm looking for, and maybe the legal world has moved on, is like some kind of knowingly standard. They cannot knowingly terminate a tenancy related to a disability.
So again, this is kind of what I walked through, I think it was last Friday.
Yeah.
You can't terminate someone's rental agreement because the person has a disability. My
Mhm.
understanding of what the request was.
That is already
is-
protected in law.
Correct. So
And,
my understanding is the request was if a tenant does something
Yeah.
that violates the rental agreement
Mm-hmm.
or is a
Danger.
violation of their obligations imposed, so they
Mhm.
damage the dwelling unit. You have an obligation not to damage it. You damage it, so you're
Right.
moving forward with a termination under that subsection. If the actions of the tenant were related to the person's disability,
Mhm.
have language to add in protections for that.
Yes,
And so that becomes, again, it's just a little tricky because the tenant does something, the landlord moves to terminate the rental agreement, and we're saying you can't do it if it's related to the person's disability, and that brings in all the questions that I was just raising.
right. So what I think the intent of the language would be is to try and say if there's a
Document,
non-violent reason that they were gonna be, that their lease would be terminated related to their disability.
So that's why I would potentially limit it to subsection A, so this would be covering only actions related to B1.
Mhm.
Because B2 is the criminal activity,
Yeah.
illegal drug activity, or acts of
But you're
violence.
saying, so you think this language is sound, or you still have a concern?
I'm saying if you wanted to limit it to the kind of,
documented disability or knowing,
before I get there, if you wanted to limit it to violations of the rental agreement or violations of the obligations imposed. So
Yeah.
now we're not talking about criminal activity.
Right,
We're not talking about illegal drug activity.
Uh-huh.
And we're not talking about violence.
yes, that can be a reason.
That would be a reason to still be able to move forward with terminating the
Yeah.
rental agreement. Then you need to limit it to subsection 1.
Yeah,
Then, separate from that, we go back to the questions that I was raising, which are
when does the landlord know?
right. At what point
Right.
in
Well,
I'm not saying you have to answer that
Yeah.
question in the statute. I'm just raising it as a flag.
Well, I love a good wordsmithing opportunity. Is this, so what if we said shall not initiate a termination? Like, we had this conversation yesterday about another issue entirely. There's a difference between when you enter into this kind of action versus finding out during. So we can't, of course, hold a landlord liable for something they don't know. That it would then be incumbent upon that person to disclose during the tenancy termination proceedings that they do have a disability, and then it's in a court of law for a judge to decide if
So-
that's
so then
reasonable.
why don't you say if a person with a disability, require the person with a disability to inform the landlord?
Well,
that.
so that, I think there's the easier way to do it is to say,
Documented, sounds good. Didn't you have documented in there first?
So I think a few things. First, I think if you just went forward with this language that you have on the page,
Mhm.
then at whatever point,
yeah,
I would argue, at whatever point the landlord becomes aware,
right,
whether it's before you issue a termination notice,
Mhm.
after you issue a termination notice, or during an ejectment action,
mhm,
that the actions that is leading to the termination itself
mhm.
is a result of an individual's disability, then
So what I
it
think
would kind of negate the termination.
I think the concern for me there is that, you know, I would want the landlord and tenant to be both equally able to debate whether or not the termination was related to their disability. Should it be disclosed in the middle of a termination hearing?
And I think they would, I mean, if you, so for argument's sake, you
Yeah.
move forward, landlord isn't aware of any disability
Right.
for the individual, something happens, they move forward with termination.
Yeah,
And then all of a sudden, the tenant discloses.
Yeah.
that here's my disability.
when they disclose
Here's the-
that in a court of law, do they have to show some kind of paperwork?
I will defer that, I'd have to defer that question to Sophie. This is, disability rights is in her.
Okay.
And when a
Tell
landlord
me.
initiates a termination or starts the termination process, do they need to articulate in some document what the reasons for it are?
There was language in the bill that required the landlord to include within the termination notice an affidavit with sufficient details with articulable facts. I don't remember the exact wording of it that was removed. So to my knowledge, the landlord isn't required to give any sort of detailed information at the point of termination notice. But subsequently, if the landlord goes to an ejectment action, they have to file a complaint in the court. And at that point, they're going to have to provide a level of information to support the termination notice that they're provided to the tenant.
And they're looking backwards as well. They could get really messy as to whether or not they had considered the disability in their termination proceeding.
So can you read this to us at the moment? Okay, so are you okay with this at the moment?
I felt more comfortable if we say shall not initiate termination proceedings, or however a lawyer would say that, and then do the rest. But then it becomes the two of you's comfort with.
Right. I think I want the landlord to know about particularly disabilities that are not visible. There are disabilities that might affect a tenant's behavior that where there might be action under number one. I think it's important there, if you're gonna exclude people, if you're not gonna hold people with disabilities liable for some of in one, I think you have to really have the landlord know that there is and I think
Well,
there's
I mean,
support here for
I
that.
think what we're saying we're trying to achieve that with the language without
Okay.
requiring someone to disclose a disability, especially if it's not visible.
Well, but if they're asking to be excused from something and not be held accountable for something, then people need to know they have.
That's
I-
the exact conversation we're having, is
Right.
how to make sure the landlord is not held to an impossible standard, that there is a knowingly standard, but that it's one that could be met with the tenant voluntarily disclosing their disability instead of being
So,
forced to
right.
before the initiation.
So we have some landlords and we have Gene, we have some expertise in the room. How would this sit, Chris, Peter, Gene?
Chris Donnelly, Champlain Housing Trust. You don't know when a tenant has a disability, and cannot ask. There is no termination proceedings. There's just a termination notice. And the language that was up on the screen.
Can you say
says
that again? There's
there's
no,
no termination proceedings.
so
There's just a notice.
Well, let's be really-
communication.
a communication that says we're entering into an eviction proceeding.
No, we're terminating your lease.
Okay, because we have what you're saying, this is all solely about non-renewal.
No,
Oh,
no, this
okay.
is well,
Isn't that eviction if it's not a non-renewal?
No, this is if something happens.
So what this language? Let's see, James shaking her head a little bit. What this language? I mean, I'm not seeing the language right now on screen, but
If you're terminating someone's lease and
bring
it's
it-
not at renewal time,
He's bringing it back up.
isn't that an eviction?
So, hang on real quick. So regardless of the reason that you are terminating and then subsequently looking to evict someone, whether
Mhm.
it's for a no cause termination or for cause termination, whether it would be for something like this, you have to provide the termination notice first.
Okay, but let me make sure this is like a huge part of landlord tenant law. We are talking about at any point in their lease agreement, terminating it early. That has no proceeding. They have no rights. They
Provide
only have,
Provide them the termination notice.
yeah,
You need to indicate the, arguably, you need to indicate what you're terminating the notice for. Because you
Yeah,
have to
terminating
give them
the
a
lease.
certain number of days notice.
Okay.
Depending on the reason that you're terminating the rental agreement for.
So that,
If it's a no cause eviction and you have a written agreement, you can't terminate the agreement until the end of the written term,
okay.
and you have to provide a specific notice period.
Otherwise, it is an eviction. Right? If you have a year-long lease agreement and you say 6 months in, they have long-term rental rights. Try not to finance. If 6 months in, you say, I'm terminating your lease for this reason, then you have to give cause. There's no cause middle of the agreement termination.
The statute doesn't say anything about how much information you have to provide. So you can give them a termination notice that says, I'm terminating your lease agreement,
6 months into a year-long lease.
and here's how much time you have.
How much time do they have?
How much
Depending on the reason,
landlord have to
it could be
moving somebody, they
the
have to.
statute up, so we talked about it. If it's for non-payment of rent, it's 14 days. If it is for terminating for breach of the rental agreement, if it is due to the tenant's failure to comply.
Okay, but the key piece here, right, is like, we've been talking about eviction as a proceeding. So what are you telling me, Chris, that if someone doesn't know their rights, you can terminate their lease without giving a reason, and there's no proceedings under that section? They would have to squat in the apartment to be given their rights in an eviction proceeding.
Correct. I mean, I think that is a.
I need to ask Jean because I'm trying to understand what exactly.
So, and
We're
before you go
thinking
to
about-
G,
Yeah,
like,
yeah.
this is very straightforward.
Yeah, it's,
To terminate a rental agreement in the middle of a written term, you have to have a reason.
You
don't-
have to state a reason, or you have to have a
You have to
reason,
have a statutory reason.
and then you have to say it to the person.
You have to give them written notice that says your rental agreement terminates on this date. And depending on the reason you as a landlord are using to justify the
Uh-huh.
termination will depend on how much time you have to give that person.
Okay,
It could be 14 days, it could be 30 days, it could be 14 under B2, right?
okay.
At that point, there is no hearing. The person doesn't get to ask for a hearing. They can ask the landlord, what's the information and what's the justification you're terminating my rental agreement? The landlord may not communicate to that person. The landlord may say, I'm doing it for this reason on this date, and here are the facts. There's no proceeding. So
Okay,
then at that point, if the individual tenant remains after the termination date specified in the notice,
uh-huh,
then the landlord has to go to court to get an ejectment action
mhm.
in order to get possession of the property.
So this is when lawyers who are advising the tenant can give sound legal advice to say, don't leave your apartment.
If
If they
I
get
don't
to
represent
that.
tenants, but if a
Yeah,
tenant
this is
came
kind of
to
why I
me-
wanted to ask.
if a tenant
Like,
came to me
Yeah.
and said, I received this notice, the first thing I would do is go to the landlord and try to get information on what the justification
Okay.
is behind the termination. And if the tenant felt that that was not justified or was incorrect or retaliatory, potentially, right?
mhm,
Then at that point, you can remain in the property
yeah,
and the tenant, the landlord would have to bring an ejectment action, at which point they would have to file a complaint in court. They would have to include all of the information supporting their termination to the court, and then you would have an opportunity to respond. So
but so are we, for some good reason, not requiring the landlord to, in their written notice of termination, to give the reason
there was,
and statute that they are being asked to leave?
well,
there
that's,
was information in the bill as it came over from the house that required information to be provided in an affidavit to go to the tenant as
Okay.
part of the termination notice, and that was removed.
that was why we had, it was part of noodling away at the no cause and providing for cause. There were for cause elements to the bill before.
But we could, in this section that we're keeping, say upon termination, the landlord needs to, I don't know about an affidavit, like we could talk about an affidavit as a separate thing, but when an eviction proceeding starts, I believe that's when the landlord is trying to put in writing their documentation of why they are evicting the person, because the court needs that documentation.
Well, that's what I think the the bill tried to get at, and Chris,
So what you're saying is because there's no one to look at the affidavit because it's not a court proceeding yet, then we can't just ask the landlord to provide a one sentence in their termination notice that says the reason for termination?
One second. Yeah.
So,
Gene,
Jean Murray from Vermont Legal Aid. So evictions for cause under 4467B say that a landlord can evict for a violation of the lease or the law.
Is eviction the same thing as termination in what you're saying?
Termination. So obviously the first step of any eviction case is a termination and then the court proceeding. So in the termination stage, the landlord sends a termination notice that says the reason that they are evicted. Now, if they say no reason, like if the notice says you are being evicted for cause and leave it at that and not say what the facts were, then if it gets to court, the court would probably grant a motion to
So-
dismiss because the termination notice does need to say what it is they did to violate the lease or the law.
Okay, so I'm confused because I feel like what we just heard was the termination notice doesn't need to say anything.
well, can we bring it back to the disability request? I'd love to, given our time, it would be, I'd love to see
I
how we
think
can make this
Our
work.
time is really well spent understanding
Well,
what we're
that's
doing.
because it's.
May I say one thing? So in subsidized tenancies, and subsidies keep changing, but
Mhm.
generally, this has
Right.
always been, if a tenant is the recipient of a subsidy, they usually have a right to an informal conference or a fair hearing with the subsidizing agency or the landlord. Sometimes the
Mhm.
landlord is both. So the notices then have to say, you are being evicted because you smoke and that your lease prohibits smoking. You have a right to a fair hearing, contact us within 10 days. And often those kind of subsidized notices also say, if you have a disability, let us know about it. Or if you're gonna raise a disability defense, let us
Yeah.
know about it.
Okay.
So that piece of termination notices have existed for a very long time in
Okay.
subsidized tenancies. It does not exist where the private landlord. So
Oh, okay.
Without a subsidy, because they're a private landlord with subsidy tenants.
to some
Subsidized tenants.
extent, some of I mean,
Some of the
we can argue that Section 8 leases require a little bit more room too.
Okay.
Right. So, on this issue that Keisha is raising, on, B1, I think. From the people who work in this arena, what would, for me, the only challenge I have with this is I would not want to use an unknown disability being the reason that somebody could say, oh, you can't evict me because I did this, but I have this disability. If
Well,
landlord doesn't know that they have a disability that would affect their need to smoke or their need for this or that, whatever the
But
need
for-
is that's not violent. I think
this
that's
goes
not
back
fair.
to the bigger question, because for anyone to know their rights can be challenging if they have a disability or, just have cognitive issues if it's not in writing. They might need to take a piece of paper. They usually would take a piece of paper to somebody who's giving them legal advice and say, what does this mean? What is happening to me? So I want every tenant to be able to get something in writing,
Well-
not just subsidized tenants,
But-
to say, this is the stated reason that your lease is being terminated.
So not every tenant has a lease that's in writing, and that would be stated probably in the lease. And that,
But
some people live.
Oh, that makes-
David,
Um,
that's all. David, you have
Well,
something?
can I stay on this thread though? Why, I'd like Jean to, as a partial step toward the idea of cause versus no cause in the future, and what could get at least terminated. what problem am I not seeing by requiring that all landlords give a written reason for termination of tenancy when they hand them
Well,
that document?
That's what we
So-
try to get.
Well,
The termination notice has to be in writing. And it has to be provided to the individual tenant. If you remember at the very beginning, we discussed actual notice. There were changes to the definition of actual notice in the House version as it came over.
Mm-hmm.
So it has to be in writing already. And you have to ensure that a person receives it via actual notice. The level of detail in that document, the statute does not specify or require.
So, but I missed this. Did you say it has to give a reason?
So my understanding.
They have to receive it.
Right. Define reasoned, you have to give them the termination notice. It has to be in writing. It has to specify, here's the date of your termination and here's how much time you have left. What I'm hearing from your advocates is the courts will say that it needs to have some level of detail to inform the individual tenant of what they're being ejected for.
But it may not be to court.
When you say reason, I don't. If I put in there that I'm terminating the rental agreement under B2 because you've engaged in criminal activity and it was on this date, do you feel like that's reason?
Well, so does this whole section only apply to a breach of a written agreement?
No, you have to provide actual notice of a termination for any reason, whether it's for cause or no cause. So if it's at the end of a written lease and you're terminating the rental agreement at that point in time, you still have to provide notice,
Uh-huh.
which is actual notice in writing received by the tenant.
I can't tell if I'm asking a question that, like, in practice, everybody, when they give written notice of termination of a lease, they give careful documentation or they share a reason. Like, if someone can just hand someone a notice right now that says your lease is terminated in the middle and that means you have 2 months or whatever that said,
Or you may have no.
am I like inventing a problem that they don't say anything to the person about why? Do they always do that?
That's the problem with no cause. I mean, that's part of the problem.
But
with
this
no-
could be, I mean, this is, I don't know that we need to open up a whole nother section to just say, let's make sure the landlord is providing a reason for termination in the notice. It could be a sentence or it could be 2 pages, but they should be providing a reason.
Well, you got language for that.
There was language and.
But it wasn't in the termination section.
There was language that said under B2, it was under subsection B, which would be termination because of a breach of the terms of the rental agreement
Mm-hmm.
or because of criminal activity, illegal drug activity, or
Yeah,
acts of violence.
Mm-hmm.
There was language in the House version that said the termination notice had to include an affidavit with actual notice required under this subsection B shall be accompanied by an affidavit setting forth particular facts and the basis thereof in support of the termination with sufficient details to inform the tenant of the reasoning behind the termination. That was only applicable to subsection B, so it wouldn't be applicable to non-payment of rent under A. But most of the other termination reasons are for no cause, so, I don't know.
Here
if-
for no cause.
If you have a 12-month lease and you've only lived at the location for 1 year and I'm terminating a rental agreement at the end of that written lease,
Yeah.
I have to provide you notice
Mm-hmm.
and it has to include 30 days.
Mm-hmm.
I don't think there's any information that I don't know what information the landlord would provide other than I'm terminating a rental agreement
Okay.
under this section and here's your 30 days notice.
Okay, so what you're saying is there is important ambiguity in the law if we continue to believe in no cause eviction at the end of the lease period.
All I'm
Not
saying,
because that's a non-renewal in my book, not a termination.
it's a non-renewal, but you still have to provide
Okay, but to me,
Termination
there's a
notice.
difference between a non-renewal and a termination in the middle of somebody's
Well,
lease.
Sure.
So I'm trying to say, if you terminated before the lease period is up.
Right.
That's different than a non-renew.
Yes.
And if you terminate in the middle of a lease period, no matter what the reason, whether there's cause or not, you should provide a written reason.
And
Can you
all-
draft that?
and all I'm saying to you is the statute doesn't.
So
specify
I like,
information
I'm
that you
requesting to draft because we
Yeah.
took out some other thing that may have been in another part of statute, but what I'm asking for here
It's for us to
to
consider.
protect everyone, but particularly people who may have challenges reading a document and understanding their rights and getting to court, is that we say in this section, if you are terminating a lease before the end of the written
The lease
agreement
period,
period,
the
the
lease
lease period, you have to provide written affidavit or
So
whatever.
we have this language already because it was in the original bill.
So what I think for future conversations, I believe there is a distinction in the world between non-renewal of a lease and terminating
At the
the
end of
lease in the middle of an agreement. We're all gonna
Yes.
have to have that conversation like that. I can't have advocates being like, no, they're the same thing.
They're-
That doesn't make any sense to me.
So
Just putting
so
that out there for the future. We
so
should be
my
talking about
point
termination
is
in the middle of it.
they're the same thing in the sense that you have to provide a termination notice.
Okay, but
Right.
now what I'm trying to do in the law is say there's a difference between what you have to do in your termination of notice if the lease period is not up.
If you're interrupting.
Understood. And,
Okay.
and so my question would be, there was language in the House version.
Right.
And I
But
would-
did it differentiate between those two things?
it was, if there is a
Either
termination of a notice under subdivision B,
Just.
It was just in a different section.
no,
It wasn't in the
it was right.
termination section because I thought we have the whole termination section still.
it was removed because it was removed in the recommended proposal of amendment from the Senate Judiciary Committee. Because
Okay.
they removed all of the changes related to the termination notice changes that were in the House.
Okay. I just, like, I'm not trying to blame anybody. I just didn't know at what point we made the decision.
Judicial.
Senate
Okay.
Judiciary.
Okay.
So it was in the original bill, and so can you pull that up for, because Keisha's been asked to go to SRE in a minute.
I'm pulling it up right now.
It's just likely to go to a committee of conference.
Probably.
Good question.
No, I mean, I assume that it will, given what we've done to it here.
This is the language that was in the House version, subdivision 3. And there were concerns that were raised with this from external parties. So I'll
Mhm.
just flag that for you all. If you're wanting to put something like this, you may want to hear from them. But it would require for terminations under subsection B. Now, you could expand that to say termination under A or B.
Right.
A being non-payment of rent. B being termination due to breach of the terms of the rental agreement. These are, those are the two,
And-
what people will typically refer to as for cause reasons for terminating a rental agreement during the period of the rental.
Okay, so I want to make sure this is specific to during
During the
the
course
agreed
of the
upon
lease,
rental.
right, interrupting the lease period.
And I think Thomas's question was a good one because usually we're looking for direction from the chair about what might go to conference and what is worth our time. Because I can let this go right now if it gets the bill out today, if there's an understanding that we're likely to continue the work.
Oh, but I think without a doubt,
Okay.
there'll be a conference committee. We just haven't discussed that yet, but I think given the amount the Senate has done to the bill, I would assume that there would be a conference
Have you
committee.
talked to the chair of the
He hasn't seen what we've done to it yet. It's waiting to see what.
Okay, so. I mean, it's just the Senate, I'm putting on every hat I have in the Senate. The Senate has to be thoughtful about what goes to conference because we don't have as many people. So I think
I think
some of these things are legitimate to go to conference over, but I'm not. I would want to talk to the chair of that committee about
I talk to them all the time.
but I mean, there's a lot of stuff they did that I don't want to conference.
Right, I
So
agree. But I have two
Yeah.
issues here for you to try and decide. One is your concern about people with disabilities being evicted for reasons that they may not be able to control under B1. And the second is, I hear you saying you would like to make sure that any ejectment, any effort to evict somebody in
Those
the
are
middle, and let me finish, in the middle of the lease period
Yes.
would need a description of the cause for what I would call for cause and what we had called before for it. And so that,
9:30, right?
okay. So that is, those are the two things I hear you asking for.
Yes,
So-
and I need to
So can we
determine.
land the disability piece first? Because I think that would be great. And then I think this other piece is important. And
Right.
I actually wouldn't mind including it here because I do think people, it is, I support for cause. So in this area, because people do need to know why.
I
they're
think there
being-
should be, yeah, I think we should be able to articulate cause in the middle of it.
Okay, but on the disability piece, because I know.
To me, they're related, so, but I can go back to the disability language. It's just the knowingly piece.
I think
It's hard for a person with a disability to then know what their rights and responsibilities are.
But-
if they have their lease terminated in the middle of their lease agreement and there's nothing in writing about why.
right, but
So they're intricately related.
but I'd love to just go back to a landlord knowing about a disability that might
That's
affect.
exactly why we need the written notice that has a reason.
So what, Cam, we have those two concerns. I think, look, for the moment, can we put a pin in that and then come back to it? Because we have a lot of the rest of it to check off, as Randy would say, we need to check off areas that we're okay with.
So to me, then the knowingly standard comes in when the landlord provides
So what,
a reason in the notice to the tenant about their early termination.
so what would the new language in B1 be to try to accomplish that?
Then it doesn't need to accomplish that.
If you were more large, that is.
Someone could disagree with me around the room, but if they
Well,
need to provide the tenant with something in writing about why they are being terminated early, and the tenant could take that document to someone who can give them legal advice, then that tenant can talk to someone who can give them legal advice about, should I disclose my disability at some point during this proceeding? Should I stay in the apartment and fight this? Should I do something different for the eviction proceeding? Because it was really important for Cameron to tell me that it's now incumbent upon the tenant, when they get this written notice, to interpret it and decide what their rights and responsibilities are after that. So in my mind, if the intent of this is to say that they, can't knowingly give termination because of a disability, the landlord is either going to be more careful about how they write that termination, or they're not going to terminate because they then know that they can't frankly put in writing that they're terminating them for something like damage, etc. If that person has a disability, they have to be more thoughtful in whatever proceedings might follow with an eviction.
wouldn't it be nice to not waste a lot of time? So that. a
It would
landlord
be nice,
wouldn't
but everybody
initiate
has rights
that.
and responsibilities, and there is more that the person with disability should be able to consider with an attorney or a friend
Right.
or whoever.
So,
That before they have to disclose to a landlord their disability.
Cameron, what language would we, in B1, would we add a knowingly state? What would
You don't have to, in my
We
mind,
don't
if
have
you
to
take
change
care of the other issue and require that they provide a written reason for termination early in the.
So I think two things. Senator Robbins, I believe you're trying to address the circumstance to make sure that the tenant themselves has the information about why the termination is being provided, so they can go and speak with legal counsel to get an understanding of their rights under this protection if it were to exist.
And that I think this would help other people who might not even have a documented disability know their rights better.
Separate from that, I think, Mr. Madam Chair, is what you're talking about is whether or not the landlord, before terminating the rental agreement, needs to be on notice that the tenant has a disability.
Right, because then that would save everybody a lot of time and angst if they would do other things to address the behavior that is would qualify for a termination if they knew and they could address it in a more productive way rather than having to begin this eviction process. That's what I'm saying.
So I think to land the first claim, Senator Robbinsdale, I think would be needing to come up with some language that could use the House version as a basis.
We have it all.
Yeah.
Try to
We
try
have
to
that
move
draft.
from there.
But focus on early termination.
Right.
Exactly.
Madam Chair, to your point, that is one of the issues that I raised with this language you have on this page right here is generally speaking, an individual with a disability is not legally required to disclose that information. And it becomes very problematic if you require that. And that's typically why landlords don't ask the question
Yeah.
because they can't discriminate against people. And so I think it could be problematic to try to put something in here to say that you only get this protection as a disabled individual if you disclose that information to the landlord.
Well, wouldn't you think that if you had a disability that might affect some of those reasons for an ejectment, you would want the landlord to know so that when that happened, you wouldn't have an eviction proceeding initiated.
I don't,
Better to
I
just
don't
leave it
wanna-
yeah. It sounds like your recommendation is to leave it as it is.
no,
No,
I don't have a recommendation. I'm letting you know that I was asked to draft this up, and if you move this forward, there are kind of policy implications that you need to be aware of. I don't have a recommendation of whether you add them or not, because these are really policy decisions for you all. I'm saying I don't want to put a value statement on what makes sense for an individual with a disability to do in these
Right.
instances,
No, I
one
appreciate
thing or the other. I don't know. I would probably defer to the advocates as far as, what actions make the most sense for the populations that they represent. I'm simply saying that if you put something like this in, you're saying that if an individual is engaging in activity, they're doing something that would give rise to a termination notice or give rise to the landlord to be able to provide a termination notice. Now you're saying you can't do that if it's related to this person's disability. My point is the landlord may not know that. And so at what
Exactly.
point does this section negate a termination if it's been provided? If you require the tenant to provide some sort of notice or reasonable accommodation request, or reasonable modification request, whatever, you're kind of going against your general policy of not requiring individuals with disabilities to have to
Right.
disclose that information.
Right.
This is now you're having to weigh landlord's ability to have notice versus the tenant's rights to not disclose their disabilities, and those are policy decisions.
Right. It's a policy decision, Madam Chair, that I would not like us to make what you're requesting.
are you okay with this language?
Yes, I am. Because, and I didn't know if you wanted to fight for your language, but I
We're
don't
not
think it's a
fighting
good
for anything,
idea
we're discussing.
because, you might have somebody who then has to disclose a degenerative disease. They might have to disclose something where they need, assistance of a support animal in the future. There are a lot of reasons in the law that we don't require people to disclose.
No, I appreciate, but if you're also saying a landlord.
But that
can't-
goes back to the other piece that's a bigger question. We need to hold all these pieces at once. in landlord tenant law.
I'm trying, my brain is exploding, holding all these pieces together. I do think though, and
So
I think there are implications here that are challenging for me and maybe for others, which is, if you have an undisclosed disability and you do something that's affecting both the apartment or the quality of life in the environs, and tenants are complaining
Mhm.
and there are, I think it is
So,
unfair to
we-
have that as an excuse.
I don't
for-
think we have a disability rights attorney in the room. I don't know, but here's what I would say, and anyone in the room or anywhere can correct me if I'm wrong. What I'm saying, this is what I'm trying to tell the committee, how we try to land this plane, is that if you were in the termination section, and in the termination section, you currently don't have to give a reason for termination. You just have to give the number of days and maybe some language about your rights and responsibilities under that.
Right.
But you don't have to state a reason. We're now in the termination section talking about reasons not to be able to terminate someone. And if someone has a disability, whether or not they have disclosed it, getting language in here that requires the landlord to provide some documentation or reasoning for the termination. If it's in the middle of a lease agreement or before the non-renewal period, then what we are saying is that that person with a disability can then take that document to someone who can help them understand their rights and responsibilities and weigh their legal options as to if, when, and how they disclose their disability.
And
So this
yeah.
language works to say you cannot terminate someone with a disability for non-violent or non-criminal reasons, and those are spelled out for
Right.
judiciary. And then that tenant has more rights when they receive that to say, should I disclose this disability now that might be degenerative or might impact my relationship with my landlord moving forward, but is the alternative that I am evicted from the apartment? And would the landlord then say, well, stay, and we can make a different argument for why you should be able to stay than you having to disclose your disability?
So coupled with the language about the lease interruptions in giving for clause,
Oh, it's not good. Yeah, I wanted to say that because that's my
I think we
intention.
would need that language to then make this work, Thomas.
Right.
Senator Weeks said it a while ago, but I
Yes,
definitely.
I know it, and I asked him, and then he said no, so.
Oh, my bad.
Oh.
Disability
I
rights.
still want to ask my
Yeah,
question.
go ahead, yeah, no,
On
but
this point,
she asked him
20
to
minutes
wait
later.
until she finished
well,
this, so I mean.
disability rights and attorney, if you feel tease on this, that's fine too, yeah. But I'm guessing that judiciary had that perspective, that I'd love to better understand what rights anybody with a disability has outside of the statute, independent of what qualifiers that we put here. And that's why I don't think we're going to resolve that today. And certainly we can come back to it. I'd love to hear from Senator Hashim. And if this does go to a committee conference, I would expect that a judiciary representative to be on there, which could also inform this decision as to why they stripped this section from Senator Reese. I'll have it in front of you.
Yeah, no,
We've had
not
40
at all. So,
Okay,
I typically don't like to dance around an issue. I like to kind of just put it on the table and address it. So this is a question I asked a couple of days ago, and I'm going to ask it again. Again, just to put it on the table, is substance abuse disorder disability? Is that what we're talking about here? Because we had a large conversation about overdose.
Right.
And I'm wondering if this thread is going all the way from, anyway, I'm wondering if this thread is all the same.
I think we have to ask our council that, because I'm not sure. I know.
This section that was requested by Senator Ron Hillsdale would apply to any disability.
Okay, so my question is substance abuse disorder a disability? I've asked this a couple of times.
That is
I
my
understand.
understanding, yes.
Okay, right, so I have a problem with the section. I'll leave it at that.
Do we problem with adding that?
I'm,
to
I'm,
this? That's fair.
it's dancing around the same issue. I just want to go right through the middle.
So that is not in our draft, so, and I agree that there is language in the underlying bill that we struck, that a committee conference could further evaluate that there's a judiciary individual on that, so I can agree.
Do we have an answer on this from our council?
I feel like I answered. He just did.
Oh, sorry,
So,
I'm
yes,
sorry,
yes, it
because
is.
Mike's joined the room and I'm distracted. So yes, it is.
That's
No,
my
it's not a
understanding. I will validate with you. I'm not a disability attorney. That's my understanding.
Is it
Yes,
substance abuse is a disability?
can be a disability, yes.
Can be or is?
These are gonna depend on the
Yeah.
facts of the case, right? I don't want to use a blanket statement and say anyone with a substance abuse problem is a disability, but.
I drink a lot of coffee. That's
Randy,
See,
to me, a big chunk of it.
Randy has a question.
beyond substance abuse. And you talk about, medical conditions that could be reasons behind the disability. Suppose you have a situation where the person has a psychiatric condition that, is manifested by their yelling and screaming and banging on the walls day and night. That's not substance abuse, it's a psychiatric condition.
just,
How does a notification or the landlord's response to that behavior affect this?
so if you were to go with the language that was being proposed by Senator Ron Hinsdale. So let's back up before I get this language. Let's look at those fact scenarios. You potentially have a situation where the tenant is, impacting other residents' ability to enjoy, the property. And so a landlord could potentially move forward with terminating the rental agreement in that scenario under subsection B1, which is the tenant failing to comply with obligations imposed under this chapter. So you're not terminating a rental agreement because the person's disabled, you're terminating a rental agreement because the actions the person is doing that is violating this section. If you were to add in something similar to this, then the landlord would not be able to terminate the rental agreement under that scenario if the actions that the tenant is engaging in are directly related to that person's disability. So if they have a disability, condition as you described,
It's not necessarily affecting the health and
manifestation.
safety of the other tenants.
If it was affecting the health and safety of other tenants, they could move forward on the second.
So no, this is, so you may not even need this subsection B, depending on where you locate this language if you were to move forward. Initially, I was asked to draft it, so the language would apply to both
One of B1 and 2.
B1 and B2, but to specifically exclude criminal activity and acts of violence. So that way it would protect drug activity if the drug activity was related to the person's disability. So that's how I initially drafted it. So you had a landlord shall not terminate under this subsection, which would be subsection B. So it would include both B1 and B2. But then to say, notwithstanding that, the landlord can terminate due to criminal activity or acts of violence if the tenant's continued occupation is threatening the health or safety of other residents, kind of similar to the language that was being discussed in the Senate Judiciary. So that's what I was asked to pull together initially. If you're going to only apply this to B1, so now we're not excluding the illegal drug activity. We're saying you can still terminate the rental agreement because of criminal activity, illegal drug activity, or acts of violence. We're only going to protect under B1 for violating the terms of the agreement or with obligations imposed. Then you don't need this. And you could just arguably have that.
So I think some of us would feel more comfortable if illegal drug activity was not included. Is that what I'm hearing from that?
Not included. So if you remove that and you included just this one sentence, then it wouldn't cover anything related to illegal drug activity. You could still terminate a rental agreement for that. Two things. This would, the scenario that Senator Brock, you identified, a landlord would not be able to move forward with a termination under that scenario. Answer to that question. But coming back to, I think, Senator Weeks's broader question, this, if you included just this one sentence, is different from Senator Weeks, your initial discussion from last Friday about this section 3. Different things. This is the person seeking the medical assistance.
Is section 3 in now or is it out? In our.
At the moment, it's in, with Randy's,
Trying to follow.
with Randy's amendment under
Yeah,
solely.
and then there was discussion about also adding in this fund.
So if we included this, illegal drug activity would not be considered a disability that could be used to, not be terminated.
You just had this sentence in and a person was engaging in illegal drug activity and they were making a claim that it was related to their disability. If you limited it to subsection 1 and the landlord was moving forward and terminating the rental agreement under B2 because the person is engaging in illegal drug activity, the protection would not apply in that instance. The landlord could move forward.
And then by illegal drug activity as opposed to illegal drug abuse. Are we saying something different? Drug activity with drug sales, for example. Now, if a person does not have a disability related to drugs, but is selling drugs, activity would fall in that category. I don't think we're intending to protect that, are we?
No.
No,
So why the word activity is?
because it-
activity in the underlying
encompasses both.
statute. That's what has been there, and I don't know off
So
the
that's
top of my
current
head
statute.
when it was added.
Okay, then,
We're not protecting it, but it's qualifying, isn't it? So it's in that activity is then,
Well, it's illegal drug activity and drug activity or acts of violence. It is additive. It is not a
right,
substitution or a synonym for that.
it could be one or the other,
That's what that says.
right?
But I don't think that's what's intended.
So the language that is being proposed here, as I mentioned, if you were to take out, add in this qualifier that it only applies to subsection 1, then the landlord could still move forward and terminate the rental agreement for illegal drug activity. And if you're asking me, does illegal drug activity include illegal drug use? Based on a plain language reading of that, I would say it does.
It does. It does. It does
It's all
not include
activity.
illegal drug sales. Though.
Yes, that's all activity.
I think it would, because that would be criminal activity.
That criminals.
But I think it probably.
I
would
think it
include
covers
illegal
all
activity as well.
I think it covers both your concerns, right? So, if substance abuse, I mean, that is. If substance abuse is considered a disability, and we're just finding that, Cameron, you know who, Katie or Jen, who are the experts in this particular area of disability?
I will inquire who is best to. If you just want
Because
direct.
I think this is amazing.
No, this is flashbacks to health and welfare in the last plan.
This is,
Up and down the flagpole.
this is a major concern, I think, to some members of our.
I will inquire as to which ledge
Okay.
council is
So-
best able to answer any questions related to that.
And-
we'll let
and-
the committee know.
Marcotte is going to show up in another minute or two to switch us before we go onto the floor. We have the person who's advocated for this change here in the room. Brenda, I'd love to have you weigh in and just say why you think this is important, because I think some of us are concerned that we don't want a non-visible disability be used as an excuse for behavior that, it's challenging. And, and thank you. Hold on. Do you have some thoughts on this, and what would you like to weigh in quickly? I just want to also say that Sophie, who is appears to be the disability rights, is able to come and talk with us about this. And I think that we're going to have to try and finish this issue if we can before we go on the floor, because I'd really like us to make some progress on this. So if you'd be kind enough to quickly wait. And Cameron, would you like to invite Sophie to join us or not?
It's up to you.
I think if it helps us get over the hurdle, then perhaps that would be useful. So if you say yes, that would be.
She's on the right.
Great. Okay.
For the
And
For the record, Brenda Siegel and Melissa Vermont. So we have clients who have been evicted for reasons like running into the wall when they are in a wheelchair, it might be a newly formed disability, for reasons like, not being able to fully read and get a document back in time because they can't read the document. So there's a number of reasons why people are evicted and they are related to their disabilities. And that's why it's critical to have this protection in the bill. I just want to name that substance use disorder is a disability, but it sounds like that keeps it from that. I wouldn't agree with that, but just to answer your question. And I think that where there is, differs in federal and Vermont law and how substance use disorder is viewed as a disability. In federal law, it's after you've entered recovery, and my understanding, and I could be wrong, not a lawyer, but in Vermont law, it doesn't. So that is, but there are lots of times when a disability that is psychiatric related disability, might be temporarily disruptive, but with reaching out to the right provider, that can also be addressed. And we want to make sure that people don't get evicted before we get the support they need. And so I think that would support a landlord in doing that, reaching out.
And so I think the language that Keisha has suggested we consider gives the opportunity, at least from her description, and maybe Cameron from yours, the opportunity, once that notice is served, the opportunity to go and take it and get help, and get help, with a lawyer, or, coming back to the landlord and saying, this is part of the reason for this behavior, and these are the things I'm either doing to help.
To be clear, if you move forward with that language that's being proposed, arguably you don't even get a termination notice because it's saying that the landlord cannot terminate. So if the landlord isn't aware and the landlord issues the termination notice, then the individual could arguably go
to legal aid, let's say, and say, I have this disability. Would you be kind enough to work with me with this landlord to share that I have this disability and that I would appreciate an accommodation in this instance? That
could happen. Yes.
Yes. I mean, the challenge is without a landlord knowing, and I appreciate that people with non-visible disabilities might not want to disclose them. On the other hand, I also don't think we want to go through unnecessary legal and action and angst if you are able to disclose a disability that might affect the tenants around you and activity and, and noise or whatever. I would think we would want to limit all that, but Thomas, you have a thought.
I would wonder if Senator Weeks would confirm or deny this, but I recall, I don't know who it was, maybe it was Sophie, saying that the substance use disorder is only a protected disability when you're not using or abusing. But if you are using the drug, that's not a disability that's protected. It's just you had this problem in the past and you're say abstaining,
And then
you're just recognizing struggling with it. But is that not the, oh, look at that. But is that like a dividing line when that is a protected class as a disability? That's a question. But I don't believe it was my sympathy, but.
Okay. Thomas, do you want to repeat
I
that
would love
question?
Senator Weeks to frame the question because he's a
Okay,
particular.
so Sophie, just to come, Cameron, would you be kind enough to give Sophie a
The
context?
question was, is substance abuse disorder, substance use disorder, however it is actually phrased, is that a disability? So my understanding is yes.
So,
Right.
alcoholism, past illegal drug use, is considered a disability, that you could request reasonable accommodations for. Ongoing current illegal drug use, not so much. So it really depends on the context.
You said illegal drug use, but alcoholism too. So if you continue to over abuse alcohol, that would not be protected.
So, I mean, I'm more familiar with this in the employment situation, but say you had somebody that was an alcoholic or had an addiction issue, from an employer's perspective, you could provide reasonable accommodations. They could go to AA meetings or whatever, right?
Right.
That would not excuse somebody from being drunk at work, violating policies, drug use at work, etc. So it's got some nuance to it.
Overdosing at work. Okay, overdosing in the,
Workplace is well trained on Narcan.
I know, I'm trying to bring it back into the conversation, which is tenants and landlords.
Right, and to what extent you have to accommodate. So again,
That's the question.
Yeah,
right,
that's the question at the moment.
right, yeah. So I mean, in terms of accommodations and for disabilities, when you're dealing with, rental agreements and things, it can be, I mean, again, the more common scenarios, which I'm sure you've already talked about, is things like needing reasonable modifications, like if you're in a wheelchair and things like that.
That's already covered.
Yeah,
in
I,
this
to be
one, right?
honest, I've not researched or been familiar with the extent to which, I mean, I can't imagine that you would be required legally to accommodate someone's ongoing illegal drug use. Again, if somebody has an issue, I mean, like, for example, a mental health issue, that having a breakdown of some kind or punch a wall or something like that, you can, again, you could request a reasonable accommodation, a sort of second chance, something like that. But ongoing issues, would not be reasonable, would not meet that reasonable accommodation standard.
So I'm going to ask a naive question, which is, if one is diagnosed with a substance abuse disorder, is that documented by a doctor?
Yes, it can be,
It
or
can be.
a
So,
healthcare provider.
again,
They're
that just
receiving
goes-
treatment or ongoing care.
Or not.
Or not. So I mean, that's again a challenge.
But this wouldn't protect tenants that continue to get really inebriated and violent and damage things, because that's not a protected.
And it's protected in the other section.
Yeah.
I mean, they could be evicted for that in that other section, if there's that consequence.
So if the landlord initiates a termination agreement and then the tenant says, well, hold on, I am protected because I am an alcoholic that's been seeking assistance, I don't know if that would really hold water.
So typically, and again, this, I'm more familiar obviously in the employment scenario, but what would happen is if you have a disability, you would work with your employer, you would let them know that you have an issue, and then you would work on in terms of having interactive dialogue on what's a reasonable accommodation for that situation. And again, in the work scenario, if you have not done that and then something happens, like I don't know, you're late for the 100th time, and your employer says, that I'm going to have to let you go for that reason. You can't then say, oh, well, it's because I have a sleep disorder and I'm not able to get up in the morning. Like, you have to have already had that conversation, right? It doesn't excuse performance issues after the fact.
So then that language is problematic.
Yes,
Yeah.
that language is problematic.
I don't support adding what Senator Rockinsdale was putting on the table, and I do trust that the committee conference with Sophie and Cam and judiciary representatives in the room to further this conversation.
Yeah.
The results are debated for this session.
No, I think that's what I've been trying to get at, is, I mean, it enables using that unseen disability as a reason to not evict somebody carte blanche. And that's, I think, challenging, very challenging. I would think that'd be very challenging for the board.
Probably why judiciary dropped this language.
Correct.
I mean, for what it's worth, I would add that Vermont Legal Aid had a presentation that I saw when I was sort of assisting Cam a while ago on this, where again, if the tenant has an issue, a mental health issue or whatever, the encouragement is to talk to the landlord up front, to talk about those reasonable modifications or reasonable accommodations that are required.
And the fine line you tread there is what Cameron's been advising us, which is it's tough. To require that a tenant do that is problematic, but if a tenant voluntarily discloses that they have this disability that may have this impact on others, that is a different thing. And I think we'll be thoughtful about that. I don't know if there's any, trying to thread this needle, is there anything that we might add that would be a voluntary opportunity to protect those who do have unseen disabilities to proactively, if they chose, have that relation, disclose that to the landlord.
You could add something into this sentence to require that if
Instead
a
of,
reasonable accommodation has been requested, the landlord shall not terminate the tenancy if the actions giving rise to the reason for the termination are directly related to the modification request.
I'd be more comfortable with a may on that rather than the shall.
Well, you can't do a may, and this is a limitation on what landlords can do. And so you can't make it permissive.
There is language already in state law around reasonable accommodations.
I know that,
Public-
but that's why I'm frustrated that we're here, because we have so many protections already for those who are disabled. I mean, there are many protections for those who are both disabled and who request accommodation for a disability. So, and the frustration is so much of the rest of this bill. So I'm going to ask, because we have so little time left and we're on the floor in 6 minutes. And the pro tem is asking us not to be late. Thomas, I know you and Randy are crunched afterwards in finance, but if we get off the floor or to go back to reasonable accommodation, might we reconvene here with our lunch for lunchtime for any of the time before our afternoon committee start? Are you okay with that, David? Randy, would you be okay with that? I mean, I'll be sensitive to the fact that, if we only have 20 minutes, I'm not going to do that. But if we have like an hour, I would really like us, if we can, to land this. Cameron, would you have time to rejoin us?
I am available. Yes, ma'am, until 3:30.
Okay, thank you. Thomas, would you think about that?
Yeah, sure, absolutely.
Let's see. Yes, David.
For forward planning,
Yes.
Tuesday, we have a box at 9 o'clock.
Jeez.
And I got
Forward
every
planning.
morning next week, so I just don't know if we're gonna keep going on H211, but I'm gonna run. I gotta go.
Right.
Let us know if you want to gather a lunch.
Okay. So you're challenged on 9 to 10. So we're thinking, as we think forward about that, could you do 11 to 1 on Monday? We spoke yesterday about it, usually, because that's what, after you and I spoke, I thought you were okay.
I think so.
Okay, anyway, if people would check, that would be great. And I thank everybody for their time. I apologize that we have not managed to land this work, but we hopefully are making some progress. Thank you very much, Counselor.
Just so I know, are you wanting that language that I was reviewing?
I think at the moment, the 4 of us find it pretty problematic. So I think at the moment,
Keep it out.
I think keep it out until further notice. But I think we have to discuss it, and I think I would not be unhappy. I would be open to the language that I think Keisha and that came from the original bill about notice with cause being served. If with proposed ejectments before the end of the lease period.
I won't include it yet, but understood.
Okay. Would you be open to that, including that? It would be adding that, because that's what she was trying to get at the first one, and then that would give tenants an opportunity to try and cure that.
There, can we break back up at?
Yeah.
12 or whatever?
I'm hoping we can do that. Yeah.
I was gonna add, there are corresponding, if you include that information in the termination notice, there are corresponding changes I need to make in the judiciary ejectment section. Require that be included as part of the complaint.
Let's chat about that. I'll ask Notter how they would feel.
Going back online, and we also have to take into account that the more things we put in like that, less likely people are landlords in the first place. And that in time, we have great difficulty.
Right. No,
Getting rental
I
properties,
appreciate
that's why rental properties, among other things, go into things like
short-term rental.
short-term
I know.
rentals
I appreciate it.
to avoid that.
I appreciate it.
And it's-
We're trying to balance it. Okay, thank you.